E ku iluna. Please rise. Auhea o ko e ko ka aha. Inahe kuliana imua o kia aha ho o kolo kolo ki e ke hano hano o ko moko aina o Hawaii. Inaoi mai, e leo mai, I lohe ia kaleo. Hear ye, hear ye, hear ye, all persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilalo, please be seated.
Right, please call the case.
Case number SCAP-23-0000460. Alvin F. Jardine III, petitioner appellant for State of Hawaii. Respondent appellee. Arguing for appellant Alvin F. Jardine III, Matson Kelly. Also appearing is Joseph Wildman. Arguing for the appellee, State of Hawaii, Ewan Rayner. Argument on the merits.
All right, good morning. Aloha, everyone. Today's proceeding is being broadcast live on the Judiciary's YouTube channel, as well as on Olelo. Counselor, are you ready to proceed? All right, we've allocated 30 minutes for each side. Mr. Kelly, you've said you wanted 17 minutes for your initial presentation, so we'll give you a warning light with 17 minutes in and 13 minutes for rebuttal. And Mr. Rayner, we will give you a warning light with 5 minutes to go. Please proceed, Mr. Kelly.
May it please the court, Chief Justice, Associate Justices. Our criminal justice system comes with an incredible price that on occasion, our criminal justice system comes with an incredible price that on occasion is paid for by an innocent person. It's without question that from time to time, an innocent person is convicted and is later exonerated. Their conviction is set aside. And our legislature recognized the inequity of having a wrongfully convicted individual solely pay this price when it enacted Chapter 661B, the Hawaii Revised Statutes. When the legislature presented House Bill number 1046, that is HRS 661B, to the governor to sign into law, it noted in Section 1 that innocent persons that were wrongfully convicted of crimes and imprisoned have been uniquely victimized, citing to many obstacles that individual will face even after being released from jail. Now, the legislature found that these individuals deserve an avenue of redress. Therefore, a statutory compensation scheme was proposed to correct the injustice, that is their words, that occurs when a wrongful conviction happens and a person serves a jail term. The legislature was clear in Section 1 of the bill for an act as to the causes of wrongful conviction. It included eyewitness misidentification, improper forensic science, and government misconduct as three of the examples. Those three items occurred in this case. Although the trial court ruled on the lowest hanging fruit in the criminal case, that is this new exculpatory DNA evidence, other evidence was presented in the petition to set aside the conviction, which dealt with all of those issues which were present in this case. Now, this case arises from a really unfortunate set of facts. A young woman was raped. The suspect was not caught at the scene, and the police had to do an investigation. And unfortunately, at that time, given the status of the DNA evidence testing, there was no result that could, well, basically the results were inconclusive.
I'm sorry,
yes.
Could you raise the microphone just a little bit?
Of course.
That might be easier to understand what you're saying. Thank you.
Of course. Thank you, Justice. So the DNA evidence that was recovered at the scene was deemed inconclusive at the time. This included there was semen on a nightgown, blood stain on a cloth that was covering the papasan chair where the rape occurred. Although our client was with his family that night and had an alibi witness, after multiple trials and after the third trial, the jury came back unable to reach a verdict and was sent back to deliberate, they finally did convict our client. Unfortunately, the Hawaii Innocence Project took up his case. And despite more than a decade passing, evidence was still kept in the locker, and that was tested at a laboratory. And Mr. Jardine was conclusively excluded as the contributor of the male DNA that was found at the scene of the crime. Most importantly, the cloth where the rape occurred. Yes.
Mr. Kelly, I think the state's argument is that that's kind of neither here nor there, because if under their presentation of the facts, you wouldn't necessarily expect the assailant's DNA to be on that tablecloth that was on the chair, because the assaults took place after that. And could you address that? Because that seems to be a important factual premise in terms of their understanding or interpreting the ruling of the Rule 40 court.
Of course, thank you. So what I'm citing to, this is the DNA lab results. This was in our both motion for summary judgment as well as opposition. Exhibit 21. And the DNA that was tested and detected, where they were able to determine who the donor was, included 2 yellowish stains on the tablecloth. Now, those yellowish stains contained a mixture of bodily fluid, one being female, one being male, and the male was excluded. Mr. Jardine was excluded as the male contributor of that DNA. So the fact that this rape occurred on this tablecloth, and there was this mixture of bodily fluids, female and male.
I thought their understanding or their presentation of the facts is that, and her testimony was, the assault took place after the two of them were seated. They sat on the chair. He forced her to call her landlord. After that took place, he then assaulted her at various other locations. So why would the fact that there was some other male DNA on that tablecloth be exculpatory, indeed to the point of justifying summary judgment for your client, which is what you were arguing for below?
Okay, and I understand that argument, but there are no facts in the evidence to say that there was any other male who had bodily fluid that could be found on that tablecloth. And the fact that there was a mixture of bodily fluid between both a male and a female on that tablecloth.
Was it bodily fluid? I understood that there was no semen found on that cloth.
Well, the semen was found, the FBI determined that the semen was found on the nightgown that she was wearing at the time of the rape. Her underwear was taken off, and she was seated without underwear on the perpetrator's lap, who was naked and
But was
sweaty.
there bodily fluids on the cloth? My understanding is that there was no bodily fluids on the cloth.
Well, to the extent that there was DNA that was taken from these yellow stains on the cloth, and that DNA contained a male's DNA as well as a female, and they could
But you
determine.
described it as bodily fluid.
Correct.
And DNA can come from things that are other than bodily fluids. And I understand that there was no semen on that cloth.
Right. Well, I appreciate that, but I would submit that there's two, not to get gross, but that there was 2 fluids that I would expect to be found on the scene of a rape. That would be sweat or semen. In regards to the sweat or semen, that Mr. Jardine did not contribute either of it because his DNA was not contained in those yellow stains.
Now, weren't there other stains found on that tablecloth? Stains that might suggest that whatever stains on that tablecloth were there for a long period of time and not necessarily a result of the events of that evening.
Well, we submit that one of the other stains was a positive blood stain contained on this tablecloth. And it's consistent with an originating from an unknown female, and that Alvin Jardine was excluded as the predominant donor of that DNA detected. All the DNA that was collected from this tablecloth excluded Mr. Jardine as the contributor.
What about the fact that that I just relayed, that perhaps whatever was found on that tablecloth was there from long before the events of that evening? And that's what I mean about those 2 other blood stains suggesting that potentiality.
Right. We submit that there is no evidence that they have regarding the duration of these stains. The fact is there are stains where both the perpetrator and the perpetrator and the complainant were sitting on the night of this rape. And ultimately what we're here about is whether or not the order that vacated Mr. Jardine's a criminal conviction, whether that is sufficient to bring a claim, because we recognize the burden of proof would be upon us in the civil case to prove actual innocence if the state contests that.
So let me ask you this, how does the order provide support for actual or factual innocence? It seems to me that actual innocence means factual innocence. So what's your position about how that order you just referred to helps your position on actual innocence?
Okay, thank you. At the time that the court was ruling on this issue, Mr. Jardine had been convicted, and this is obviously his petition to set aside, to vacate that order. The criminal trial court judge, Judge August, 3 times in that order cites the fact that the DNA evidence was potentially exculpatory. And that's a word that wasn't required under the McNulty standard. He didn't have to find it to be exculpatory to set aside his conviction. But when looking at the circumstances of this case and this new DNA evidence, he used that. And I would submit that exculpatory is what we would expect evidence that would exonerate someone. That's what would be stated in the order. And to hold Mr. Jardine's counsel, sorry.
I'm sorry, Mr. Kelly. So the state argues that, you're sort of saying that there was evidence, or the order referred to evidence that was potentially exculpatory, but the state argues that the version of the bill which was ultimately enacted requires more, that it be a finding that's either of actual exculpation or actual innocence or the equivalent. And they point out to the fact that an earlier version of the bill had language that said something to the effect of the conviction had to be reversed or vacated on grounds consistent with innocence and supported by facts that clearly state such consistency. And the ultimate version, in their view, was a stronger, more restricted version. So how do you address their plain language argument, and how does the allegations that were made by your client or the information put forth in response to the summary judgment sufficient?
Thank you. Yes. At the time we argued this in our trial court, the Giri versus state decision from the Intermediate Court of Appeals hadn't come out. The sole issue before the court at the time was, were these magic words, actual innocence, contained in the vacature order? In fairness to Mr. Jardine's counsel at the time, that's a legal standard that, as far as we're aware of, did not exist in the state of Hawaii. So to say that at the time of vacature, that the trial court was required to use this term that didn't exist, we find is, well, using the ICA's word, it would be absurd. And we supported that. I submitted a declaration of Philip Lowenthal, and a lawyer practicing criminal defense for 50 years on Maui, and he's never heard of that standard being referenced in a criminal case in 50 years of practice on Maui. Now, yes, I understand that the argument quickly shifted now that the ICA has given us some insight. Now the state has taken back this argument of these exact precise words having to be uttered in an order. Now it is that it basically needs to state, it needs to, the order needs to go to the issue of actual innocence, but not necessarily precisely state that. We submit that in this case, where we have evidence that excludes our client, DNA evidence, in a case involving a misidentification, basically all the evidence in this case just goes to whether he did this or not. This is not a case involving the suppression of a statement or jury instructions that went sour. That wasn't the reason for this vacature.
Counsel, would you agree that Judge August did not make a finding of actual innocence?
Absolutely. And
Right.
that was,
and when he applied the McNulty and Caraballo test, that's not part of the test, is it?
that is correct.
Right. And the statute came in 2016, so he's not even aware that's part of the standard at the time.
Correct. Yes, I agree with all of that. And those are our arguments why their interpretation is not fair. And as the
Do
ICA
you
said,
agree
it was
that we
absurd.
should apply the guilty standard to this case?
We do. Yeah.
And
It's-
what's the standard that you're offering?
Well,
Equivalence?
Exactly. Yes. There needs to be an order issued that's the equivalent of actual innocence, meaning an order that goes to whether or not a person committed the crime, such as, and the examples given by the legislature in passing this bill deal with that. They're saying that wrongful convictions occur when there's misidentification, or maybe the science has changed over the years, or They cite to
Right,
basically
but
government
DNA wasn't
misconduct.
the only evidence in this case, right? There was other evidence pointing to Mr. Jardine as being the perpetrator. There was identifications, there were photo lineups, and so on.
And those issues were contested when in the petition to vacate. The court only ruled on the DNA evidence because it met the McNulty standard and didn't need to go beyond that. But all those issues were raised in this case. The
No,
photo,
and I agree. And it merited a new trial, and that's all that ruling was, correct?
that is correct. And
Okay. And part of that McNulty test, though, is probably a verdict would turn out differently. Is that a preponderance of evidence type standard?
that's a good question. That's what we submit is that for the court to find it's probable.
You never argued that. I'm asking you. No one argued that. And I'm asking you, is that a preponderance of evidence type standard incorporated into that McNulty test? When they talk about probably, it would result in a different verdict.
Yes, because there's two verdicts, guilty and not guilty. Obviously, at the time he has to set aside his last verdict was guilty, and the court found it probable it would be not guilty, meaning he didn't commit the crime.
More probable than not?
Correct. Probably being 51% or more.
Is that what you're arguing?
Yes. Thank you.
Let me ask you this. You know, you mentioned that the functional equivalent test that sort of derived from Gidi applies to your client because your client raised the Rule 40 prior to the new law. What about post 2016? If some claimant came in, is the functional equivalent test worthy there, or do we need the actually innocent words?
You know, I submit that functionally equivalent is the only fair way for this law to be implemented. And the reason is the time a judge is ruling upon a request to vacate a sentence, what occurs is the court is setting aside the prior conviction, and there still is a pending criminal charge, and guilt and innocence is in the purview of the jury. So to have the court, in setting aside a conviction, be charged with, be responsible for determining if someone is actually innocent of a crime creates issues. And you know, I mean, playing Monday morning quarterback in this case, we could say, well, perhaps in that situation, after a not guilty verdict, then there should be a post-proceeding motion in a second trial where the judge determines actual innocence in the criminal case. I don't believe that makes any sense.
Are you suggesting that after a trial, a defendant can come in and request the court to make an actually innocent finding? Because 663B1 talks about reversed or vacated, which really is derived from a Rule 40 matter. So it doesn't matter what ultimately happens if the person's found innocent or rather not guilty after trial, right?
Correct. Yeah. In this case is, I think, even more egregious where the state ex parte out of court obtained a dismissal. There wasn't even an opportunity to have a not guilty, to have these facts fleshed out to see how the trier of fact would determine his guilt or whether he was not guilty. But especially now, depending on the interpretation of this, I do think it would be a burden on the court and unfair if somehow there would have to be some post-proceeding criminal determination of actual innocence, especially considering when the legislature passed this bill, they put the burden on us in the civil case to prove actual innocence. So if we required the criminal court to do that, we would have two trials in the same issue, basically. Two finders of fact dealing with the exact same issue. You know, the bill is clear. Our burden is preponderance of evidence, prove actual innocence if the state contests it.
Counsel, can I ask you, would you agree that not guilty doesn't necessarily mean someone is innocent?
Absolutely. Yeah, I agree that not guilty beyond a reasonable doubt doesn't necessarily mean, it's not a finding of actual innocence. Certainly there are cases where maybe a procedural issue occurs and that could result in it just as in the Gidi decision. That wasn't the result of a not guilty verdict. That was.
Well, that was impossibility in
Correct.
Gidi. You know, and I was wondering, just as a side issue, why you didn't cite Gidi in your opening brief. Is that something, it came out a few weeks before you turned in your opening brief. Is that something you just weren't aware of, or did you decide consciously not to argue that standard?
Yeah, thank you, but we were not aware. At the time, we've.
Fine, I understand. Thank you.
Okay.
And you, are you seeking summary judgment? I know you had a cross motion for summary judgment. Is it your position that if we agree with you that whatever the threshold requirements in B1 are, that the state, that then the court should have proceeded to And I think it actually did in some ways. It's a little hard to understand, but it appears to have also gone to the merits and said that as a matter of law, you weren't entitled to judgment on the merits. What's your take? In other words, if we agree with you that whatever the threshold requirement imposed by B1 has been met by your client, what happens next? Is it summary judgment for your client? Is it send it back for a trial or what?
I believe that granting the summary judgment is correct, that our summary judgment. And the reason is that the trial court in our civil case found, quote, undoubtedly there was an improper and lawful incarceration. The sole issue that the court relied upon was the magic word argument by the state, that actual innocence wasn't uttered in the vacatur order. Now, why summary judgment should have been granted in the civil case is the state's opposition to our motion for summary judgment didn't contain a single declaration or piece of evidence. We supported our summary judgment with admissible evidence, including the declaration of Mr. Jardine saying, I did not commit this crime. We contained the certified order in the criminal case with all of the findings contained therein regarding the DNA evidence, excluding as the male perpetrator. Yes, sir.
Counsel, I got the sense that Judge Quano was struggling, you know, and seemed to be almost leaning, but he was stuck with the language. He didn't have that plain language, and it seemed to cause him pause because he seemed to be making, giving some thoughts that he thought it was unlawful. If it's unlawful, then the basis was what you folks were arguing at the time. Is that the sense you had?
Absolutely. And I couldn't have found stronger words used by the trial court, considering he ruled against us. But he still said words like, undoubtedly he was unlawfully incarcerated.
Harsh result.
Repeatedly. Harsh result. Yes. It was, I think it was a difficult decision for him because he understood the gravity of what this was. I mean, this is a law basically.
But he didn't want to contravene the statutory language. That's the sense I got when I was reading the record.
Correct. And I think he even explicitly said we need to have this interpreted, that this needs to be addressed, because at the time it was our understanding it was a case of first impression, although Guidi snuck up on us and that case was decided by the ICA after these motions were heard.
So come back to the question I asked a while back, which is how do you get around the fact that the original version of the bill said the conviction was reversed or vacated on grounds consistent with innocence and supported by findings which clearly state such. So that's where the bill was. It ended up with actually innocent, and the decision so states. Now the state says, hey, that's a much higher standard. And are you arguing absurdity of results? Are you arguing ambiguity that we should then resort to the alleged history? What exactly are you arguing there's another interpretation of that plain language? What exactly are you suggesting we should do?
I believe all those apply. I think it could result in an absurd result. I believe there's ambiguity, as the ICA pointed out. It's not clear. Actual innocence wasn't defined in this bill. And really, at that point, if we go to the bill for an act that was presented to the governor to sign, and we look at what the legislature wanted to do, I mean, it's clear they wanted to compensate someone wrongfully convicted. It states a convicted person is considered exonerated when the person is later officially declared innocent of the crime. And then it says nationally, there are more than 1,700 persons listed on the National Registry of Exonerations, including 3 persons that were convicted in Hawaii. What they're referring to is this National Registry of Convicted Persons maintained by the University of Michigan's Law School. Those 3 people they were referencing, Mr. Jardine was one of them. In fact, he was the oldest case. This bill was basically, the ledge passed it, citing to him as an example of why it's right to have someone who's been wrongfully convicted.
You're not suggesting that's the finding of actual innocence, are you?
What's that? I'm sorry.
You're not suggesting that the legislature's finding that you just read we should consider?
No, but the purpose of this is to compensate someone in Mr. Jardine's circumstances, and they really did go short of defining it. And I understand that's why the Guidi court ruled the way it did. Is we're going to have to give ordinary meaning to the terms actual and innocence. We're not dealing with an issue of and when we look at the cases across the country, although they do point out that those other statutes are our statutes unique to these other jurisdictions, it's clear that the purpose, what they're trying to get at with the ledge, using these words like actual innocence, is this isn't to compensate someone who got off on a technicality. This is to compensate someone who is innocent because they didn't commit the crime. Thank you.
Mr.
I'm
Kelly,
sorry.
There's a difference between this case and Guidi, though, in the sense that in Guidi, there's no question as to the count that was in fact allowed to go forward. It was legal impossibility, right, in that situation. This case is different because it's based on the evidence, that one piece of evidence that was DNA ultimately determined excluded your client. So it's a different kind of a circumstance, right?
Sure. It's definitely a different circumstance, although our case, as noted even in the vacatur order, came down to the issue of an identification. This was a cross-racial identification with what they called a loaded six-pack, meaning that there was one person when the complaining witness was shown the photo ID lineup that matched the description. No one else did. And the newly discovered evidence goes solely to the issue of, was our client there or not? It goes to whether or not he perpetrated this crime. So we submit it goes to the issue of innocence, whether he was actually guilty of this crime.
Right. It's just a question of what you may need to prove, though, to actually show actual innocence in this case, as opposed to a situation where it was legally impossible for Mr. Guidi to have been held to account for sex assault in the third degree, given the statute at play, and that he was accused in that case of sexual assault in the third degree of his wife, which was not part of the offense, right? Given how the statute read back then.
Correct. And we submit as the 661B is enacted into law, meaning that we have, if they contest actual innocence, it's our burden to prove it. We accept that. If they cannot present facts in dispute, in other words, overcome the summary judgment standard, then yes, at trial, we have to prove actual innocence by
The
preponderance.
statute contemplates, and the statute here, 661B contemplates a trial.
Correct. Yeah, and places a civil burden on us at trial to prove actual innocence. Thank you.
I'm sorry,
Yeah,
Counsel,
Justice
if I
Stephens,
just
please.
may, just a quick question. I'm curious. Was a reason ever given as to why the state did not retry Mr. Jardine?
They did not. And this was, the dismissal was ex parte. And I I'll point out one thing is that, this statute is very meaningful to our client, not just because of compensation, because it gives him a day in court. And this, where he sat in jail for 20 years, finally there's evidence that came out regarding DNA. And the reason that came out is because he was contesting his conviction all those years. It was a miracle anything was even left at that point to have ruled upon. But to finally get to a place where, yes, it was the conviction was vacated and he was looking at his criminal trial, and then to be dismissed when he wasn't even in court, this 661B gave him that. It gave him finally a day where he could go to court and prove his innocence. And he is deserving of that day. I'll say
Well,
that.
was it not only DNA evidence, but also the fact that in the early 90s, eyewitness identification and the procedures, methods, protocols that go hand in hand with eyewitness identification were pretty much backward, and things have changed. So you have more than the DNA evidence, don't you?
Absolutely. And that was contained in the petition, although I don't think the court had to go that far to set aside his conviction. But yes, the petition to set aside by the HAWAIʻI Citizens Project addresses that, all because it became more empirical data was used to show the unreliability of this eyewitness identification, especially when it's interracial of another race. So, thank you.
Very well. Thank you, Mr. Kelly. Mr. Rayner, you're up.
Good morning, Chief Justice Recktenwald and Associate Justices of the Supreme Court. My name is Ewan Rayner, Deputy Solicitor General, arguing on behalf of the state. Your Honor, the question at issue today is not whether the court believes that the petitioner was actually innocent, nor is it whether the court believes that the state should compensate petitioner for wrongful conviction. Rather, the question is whether the statute actually enacted by the legislature, specifically HRS 661B-1, permits the petitioner to seek compensation in these circumstances. But the version of the statute the petitioner asks this court to apply today is not the version of the statute that the legislature actually enacted. Now, the legislature was very clear when it enacted Chapter 661B that to be eligible to file a claim for compensation, the decision that vacates or reverses the conviction must do so because the petitioner is actually innocent. And it also includes a requirement that just expressly states that. Now, as the ICA recently concluded in the Guiti case, although that standard doesn't necessarily require the court vacating or reversing the conviction to use the precise words actually innocent, what it does require is that the finding, which is the basis of the reversal or conviction, be equivalent to actual innocence. Petitioner, however, asserts that it's enough if he presented some evidence of his innocence, or that the conviction was vacated on grounds tending to show innocence. That, though, is the exact standard that the legislature considered in 2015, but rejected in favor of the version of the statute it actually adopted in 2016, which requires the conviction to be vacated because the petitioner is actually innocent. Now, based on the language of HRS 661B-1, the main question the court has to answer today then is whether—
Counsel, I'm so sorry, but you initially started your argument by saying that the legislature enacted 661-B-1, but then you also indicated that they enacted the entirety of Chapter 661-B. Now, it appears your argument is that you can't even file a claim for compensation unless the court order setting aside the conviction said that the defendant was actually innocent. Is that—
No, that's
right.
not our position. You know, particularly pursuant to the ICA's, we've essentially adopted the ICA's position, the ICA's decision in Guiti. So we are not taking the position, I want to be clear, that there has to be the words actually innocent, or the court has to say I am vacating the petition because the defendant was actually innocent. We're not taking that position. We do agree with the ICA in Guiti, though, that there does have to be a finding, or at least sufficient evidence in the record to demonstrate that the criminal court vacated the conviction for a reason that was equivalent to actual innocence. Now, I think there's several ways that the—
But counsel, wasn't that the finding that Judge August made? He said that probably the verdict would turn out differently. Isn't that a more probable than not preponderance on the evidence, which is what 661B requires?
I would agree that the McNulty standard is a preponderance of the evidence standard in that—
Which is what 661B requires as well, doesn't it?
661B requires the petitioner to prove by a preponderance of the evidence at trial, assuming they are eligible to file a claim, that they are actually innocent. But the question is, what is the standard of actual innocence? So by proving by a preponderance of the evidence that the jury would probably, or more likely than not, change its verdict in light of the new evidence is, in our position, not the same as proving by preponderance.
What would the verdict be changed to? It would be changed to not guilty.
Right, but this court and the U.S. Supreme Court and virtually every other state court that has looked at this issue, interpreting their own compensation statutes, has held that an acquittal and not a not guilty verdict at trial is not the same as innocent.
I understand that, but what I'm struggling with is, it was in 2011 when Judge August is examining this case. The 661B had not been enacted yet. So are you saying it was in that proceeding that he was supposed to come up with a finding equivalent to innocence?
Yes, I mean, that's exactly what the statute says.
Isn't that an absurd result, though? Because it's impossible for him to have known what the statute was.
Well, I would respectfully disagree, because I don't think it's impossible for it to
How would he know that that was the statutory requirement in 2011 when the statute wasn't enacted until 5 years later?
Well, we wouldn't know, but at the same time, there was nothing to prevent the petitioner, when he brought his Rule 40 petition in 2011, from pursuing an actual innocence claim.
But he wouldn't know that was the requirement at the time, because the statute wasn't on the books. And the McNulty test and the Caraballo test don't require that type of finding. And that was the law at the time.
That's right, but seeking filing a later petition for compensation would not necessarily be the only motivation that a Rule 40 petitioner might have. Now, although it's not particularly common, it's not unheard of for petitioners, for example, to Rule 40 petitioners, I mean, to also seek not only vacation of their conviction.
But let's talk about this case and the facts in this case. It was 2011 when this conviction was overturned based on the case law and the factors and tests as it existed at that time. There's no requirement of innocence. In fact, the defendant's never required to prove his innocence in a criminal trial. That burden is on the prosecutor.
But the burden's on the prosecutor to prove guilt beyond a reasonable doubt.
Every element,
But
correct?
what the petitioner could do as part of a Rule 40 petition, as well as seeking a new trial, they could seek to have the charges dismissed, which would require...
Well, you did that for him.
I'm sorry?
You folks did that for him. You dismissed it with prejudice.
They did that around 5 months after the Rule 40 petition.
Doesn't that bring everything back to square one with the presumption of innocence?
No, it doesn't. At least certainly not for purposes of HRS Chapter 661B, because the focus for determining eligibility to file a claim for compensation has to be on the decision that vacates or reverses the conviction.
What if you had given him notice of your attempt to dismiss the case with prejudice? Wouldn't the petitioner then have had some options at that time?
If it hadn't been dismissed.
Well, at that point, they still didn't know that this was going to be the law. So what I'm really confused about is 66B-, you say that there has to be a equivalent of a finding of actual innocence, whatever that might mean, under 661-B1, in order for a petitioner to even file a claim, right? But then 66B-3 says that the petitioner then has to prove that he was actually, by preponderance, that he was actually innocent in a trial. So if the standard was the same for filing the petition as what he had to prove, why does that make any sense to have the same language and the same standard for filing the petition and then the proof that the petitioner has to make after a trial?
Well, so there's a couple of points I'd make about that. The first is that, I think, however you think that, whether it's a good idea to do it like this, the legislature has the prerogative to set up this process how it deems, how it wants to. And I think one thing that is pretty clear from the way the statute's written is that that's how the statute is supposed to work. But I would also say, I do think there are,
in terms of Rule 40 petitions, how many Rule 40 petitions have been decided in which judges of the state have said that the defendant is actually innocent?
I'm not aware of any. But I do know that, if for example, if you do a Westlaw search, it's something that is frequently raised by petitioners in Rule 40 petitions. This court has never actually addressed whether a freestanding actual innocence claim is viable, or if so, what the standard would be. But there's certainly, I don't think, anything that would preclude a petitioner from trying to bring that. And, particularly in light of the fact that several other states have ruled that as part of the state constitution, there is a freestanding actual innocence claim. And in determining what the standard is for that, they've looked at, for example, the US Supreme Court's decision in Schlupp versus Dello, which was cited, I think, in both of our briefing, although the prevailing standard that states have adopted, they've adopted a slightly higher burden of proof than the Schlupp case, because Schlupp involved a habeas proceeding, and the actual innocence claim in Schlupp was a procedural one, meaning that the petitioner had to prove a colorable claim of actual innocence in order to allow the court to overcome the procedural bar and reach the underlying constitutional question about the infirmity of the trial. And because that was a procedural actual innocence claim, the Supreme Court adopted the standard that the petitioner would have to prove by preponderance of the evidence that no reasonable juror would find the defendant guilty. Now, state courts looking at substantive freestanding actual innocence claims have generally adopted that no reasonable juror standard, but under a clear and convincing burden of proof, because the rationale being that a higher burden of proof is appropriate when it's a substantive.
This to the statute? I'm sorry, it's a very interesting discussion. I'm trying to understand how it helps us. I'm still back with Justice McKenna. There's Section 1 seems to set some kind of a threshold bar of this is what you have to allege in good faith, I guess, or you have to be able to point to the order and say, this is what the order said, to get to a trial. And there's a purpose of helping people who've been wrongfully convicted, having a way to exonerate themselves and receive compensation. And then there's a trial. So I think her point is if you adopt the very narrow reading or the very high bar that you argue Section 1 establishes, why would you need a trial? Because basically you're saying what you needed here was for the DNA to come back to some other person who then confessed to the crime. And okay, then I guess you would, at that point, you'd say, okay, that's actual innocence. But failing that, you need a trial. And why does it make any sense to have a trial and have such an incredibly restrictive threshold requirement? It doesn't seem consistent with the purposes of the legislature as articulated in the history.
Right. Well, I guess 2 points I'd make in response to that. And the first, I think, is that I think that would be a much greater concern if, we were insisting, or, our position was that there had to be an explicit actual innocence finding in the decision vacating or reversing the conviction. But because, the argument, the decision in Guiti and our position is that it has to be equivalent to actual innocence. There are multiple ways, I think, to get to that point, to the equivalent of actual innocence. And I think, for one example might be if, as part of the Rule 40 petition, the criminal court not only vacates the conviction, but decides that the evidence is so strong that it warrants dismissal with prejudice, for example. That I think would be a very strong indication that the conviction was vacated because of actual innocence. But at the same time, the actual innocence wasn't necessarily directly an issue at the Rule 40 petition. And so I think that would warrant then the civil trial on the actual innocence question. And the other point, I think, is that the evidence submitted at the two different proceedings, the Rule 40 petition and the later civil trial on actual innocence, would likely not necessarily be exactly the same. Generally, when a Rule 40 petition is brought based on new evidence, the evidence is generally going to be the trial record, and then whatever newly discovered evidence there is that couldn't have been presented at trial. Whereas in the civil proceeding, it's going to be a much broader range of evidence that's going to be available. And so it's not necessarily going to be completely duplicative.
Well, wouldn't that lead to inconsistent results? I mean, you have an actual innocent finding, then you go to this preponderance standard, and then there's a different finding. Isn't your argument really the difference is the affirmative defenses possibly that's in there? I mean, I sort of tend to agree to the suggestion that, why even have the second go around on the actual innocence? But there are some other things that have to be shown. Maybe that's the reason.
Yes, certainly. And then, HRS 661B-3 there's a whole list of affirmative defenses that the state has the opportunity to prove at the civil trial. And so that's, I think, another reason why there would be a separate civil proceeding. And again, whether the court thinks, if the court thinks sitting in the legislature's position it would have done the same thing is not necessarily the question, because I think the legislature had the prerogative to set up the process in this manner if it deemed that was the most appropriate way to do so.
Well, with regards to that, then, Chief Justice asked earlier regarding the original version of the bill that was introduced in 2015. It didn't go anywhere. It carried over to the 2016 session. And then the HD1 version was very different. It's essentially the same version that we have now, right? The HD1 version that added the actual innocence language and that the court so state in the first section of the bill. What is your understanding as to what the concerns were with the original version of the bill that led to the HD1 version?
Well, I mean, I think
there's nothing in the legislative record that
so we cited in our brief, there was some testimony from the AJS committee co-chair who testified that the changes were to better balance the interests of wrongfully convicted persons with the limited resources of the state. That
That's
was
one of the things that were.
that
was
that
in
was
the-
one of the things. But I mean, I think when you look at that and you look at the type of changes that were made, making it essentially more restrictive, the logical conclusion is that that was the basis for making those kind of changes.
There's nothing specific in the legislative history that speaks to the language of, and that the court decision so states. Is that true? There's nothing in the legislative history that illuminates that.
Right. I don't believe there's anything in the legislative history that specifically references that that provision. Or
3 out of the 5 committee reports that I've seen indicates that the purpose was to allow a petitioner to demonstrate that they were actually innocent. Shouldn't that matter in our interpretation of the language that was used?
Well, so as I read the purpose section and some of the committee reports, I think what the legislature indicated was that they didn't intend to open up compensation for every person whose conviction is vacated or overturned, or even every
Right.
quote unquote wrongfully convicted person. That one of the committee reports says here that it uses the word, the conundrum is to determine who is deserving and who is actually innocent, as opposed to those who are not. And I think when you look at that and then you look at the plain language the legislature adopted, it seems to me that what they were trying to do is that 661B-1 provision is a kind of, it's a gatekeeping provision, essentially. They didn't want to open this up to anybody who might have had their conviction overturned for any reason.
It says the petitioner shall allege in that particular section.
Right, but then also in 661B-3, they also then later require that to be proven beyond by a preponderance of the evidence as well.
Right. Which is the section 3. Subsection 3 is a section that deals with having a trial before a judge, or if so determined via a jury on the civil claim.
I'm sorry, could you?
Section 3, subsection 3 of 661B also is the section that speaks to having a trial
Right,
with
that's
regards
right.
to the civil claim.
Yes, and so under that section, the petitioner has to prove not only, well, they have to prove that they are actually entitled to seek compensation pursuant to the gatekeeping provisions in B-1, and then also prove beyond by preponderance of the evidence that they are actually innocent.
So in that,
Go ahead.
if we were to set aside the grant of summary judgment in favor of the state, and we were also to decide that the petitioner is not entitled to summary judgment, and we remand for a new trial, a trial would be for the petitioner to prove that they are actually innocent. And so then they would bring in the additional DNA evidence that was now ascertained. And then in terms of the eyewitness identification issues, would it be our current law that has since, as indicated by my colleagues, that the law has really changed our understanding of eyewitness identification, and we have established additional standards for the admission of eyewitness identification testimony, or at least instructions. So would the eyewitness identification evidence be judged by our current standards?
Yeah, I think the civil trial would essentially, assuming that the court were to disagree with the circuit court, that the gatekeeping provisions were established and vacate the summary judgment, the civil proceeding, I think, would essentially open up to all of that kind of evidence. Yeah, I don't think, it certainly wouldn't be nearly as limited as in the Rule 40 proceeding, which I think is another reason why it's not necessarily an absurd result that the legislature set up this process by which there had to be a separate civil trial to prove actual innocence, because the range of evidence that could come in, it can be a lot broader.
Coming back to Justice Devons's point, why isn't it sufficient that the Rule 40 court found that there was a reasonable probability of the DNA evidence changing the jury's verdict? Why isn't that enough of a finding to get the petitioner to trial?
So, I mean, a couple of reasons. I think under virtually all of the substantive actual innocence standards that other courts have adopted, that McNulty standard would not meet
would not rise to the level of actual innocence. And an example of that is a lot of the states who have adopted freestanding substantive actual innocence claims have adopted that the SHLUP no reasonable juror standard, but by clear and convincing evidence. So I think that's the first reason. The second, I think, is that if the court were to interpret 661B as allowing compensation or claims for compensation based merely on the meeting of the new trial, the McNulty new trial standard, you end up with the result where a petitioner is eligible to seek compensation and potentially even receive compensation when they still face the possibility of being retried for the same criminal charges for which they were ostensibly found actually innocent under 661B, which is sort of an extremely problematic result, particularly in that 661B doesn't, it wouldn't be in any regard to what result would be at the
But in
criminal
this case, the
trial.
Rule 40 judge did order a new trial, correct?
I'm sorry.
In this case, didn't the Rule 40 judge initially did not say the case is going to be dismissed with prejudice?
He didn't dismiss at the Rule 40.
Right.
petition,
Initially,
right.
there was going to be a new trial.
He ordered a new trial.
Right.
Right. But and then
And I'm not sure what would have happened in a new trial, but gee, what if the petitioner was found not guilty in the new trial?
I mean, if it's gone to a new trial and found not guilty, I mean, by the plain language of 661B, that wouldn't be sufficient because the focus has to be on the decision vacating or reversing the conviction. Now, I think what could happen is after the court ruled on the Rule 40 petition and ordered a new trial, there were then about 5 months before the prosecution moved to dismiss. And, as I think was mentioned earlier, there's no real reason in the record as to why that occurred. But in that 5 months, it would have been possible for petitioner to seek to have his claims dismissed. The court even has its inherent authority, as this court has held before, to dismiss charges sua sponte if the circumstances dictate that's appropriate. And I think even though the focus of 661B-1 is on the decision that vacates or reverses the conviction, if it does that and then subsequently dismisses the charges, especially with prejudice, and there is something in the record to indicate that that is related to or for the same reasons that it vacated the conviction, I think that would be very strong evidence that the gatekeeping provisions were established.
If every Rule 40 petition that is granted and a conviction is vacated, new trial ordered, if after every one the state routinely moves to dismiss the case with prejudice and does not allow the case to proceed, what effect would and we adopt your arguments, your legal arguments, how would 66B-1 or Chapter 66B be effectuated?
Well, again, I think it would be more of a problem if it, for example, okay, so I think I have two responses. One is that the petitioner could seek dismissal as part of the Rule 40 process, and then the court would rule on that, which would sort of preempt any dismissal by the prosecution. Secondly, I think it would be more of a problem if it happened immediately after the Rule 40 order, whereas in this case, there were at least 5 months afterwards in which the petitioner could have acted to seek to have his charges dismissed, or the court itself could have dismissed the charges. So I think, at least in the factual circumstances of this case, I don't see that as an issue. And especially given that the Rule 40 allows the court to issue pretty broad relief, and so especially given that I think that this dismissal as part of the Rule 40 process would be an option, I think the petitioner has an opportunity to make a claim that would be equivalent to actual innocence before the prosecution would ever dismiss.
Can I ask you on that? Because what would be the motivation to do that at that time? Because everything happened in 2011, and then you have the statute coming out in 2016. What would motivate or cause Mr. Jardine to pursue such a remedy?
To avoid him being retried, to have his charges dismissed. I think that's pretty strong motivation, I would think.
But you folks had dismissed it within 5 months. I mean, there's really nothing left for him to do at that point.
After the dismissal, yes. But, my argument is that could have done that either as part of the Rule 40 petition or in the 5 months afterwards.
So,
Check with.
oh, no, so it seems that you are agreeing there's not precise words that are necessary. If an order has the functional equivalent of actual innocence, that is all right and sufficient to make an actionable claim. In this case, you moved to dismiss, with prejudice. There was not any explanation, such as perhaps we have witness issues, which would not be a finding of actual innocence in that situation. Just nothing. Then we have the classic 1990s eyewitness stuff that is really not sufficient nowadays. Then we have the courts, Alvin Jardine is excluded as a possible donor of the DNA detected on the sample, conclusively excluded language. We have the language that Justice Devins talked about that Judge August mentioned. Can you explain how this order does not show or is not the functional equivalent of actual innocence?
Yeah, so I mean, I think there's two reasons for it. One is that I don't think the McNulty standard is the same as the generally accepted standard for actual innocence, just as a legal
Okay, but
matter.
aside from just McNulty and all that,
Okay.
these were the findings of the court. This is what the court said.
Right. So, and based on the specific evidence in this case, I think, so even if the court were to disagree with me as to almost all of my arguments about dismissal, about McNulty not being the same, I think even at that point, the court would still have to look at, well, what are the specific factual findings that the court made in determining that the McNulty standard was met? And of course, not all new DNA evidence is created equal. Some new DNA evidence in hypothetical cases might provide, almost complete evidence of innocence, assuming that it's credible and assuming that it's not contested. But in this case, the new DNA evidence is very, very far from the court could conclusively exclude him, but it's very far from establishing that Mr. Jardine was not the perpetrator, because the new DNA evidence was tested on a single piece of evidence at the crime scene. It tested 4 stains on there. But there are still significant questions as to any of those stains.
Well, there might always be questions, and I think you were probably going to add to what I asked Mr. Kelly earlier on the comments about, the age of the tablecloth and all that. But, aren't you suggesting that this particular order and its functional equivalency almost has to require that the defendant come in and prove somebody else did it? I mean, is that the standard? Isn't it? I mean,
I wouldn't go so far as to say that the defendant has to prove, like, who literally the other person, the different person that did it. But I do think it would have to go a lot further than the evidence in this case established. In this case, it's not even clear. And we talked about the where the stains came from on the tablecloth. But for example, none of the findings that the civil circuit court made in this case have been challenged on appeal. So those are all binding. And the new DNA evidence, it states that presumptive testing for semen on the tablecloth was negative. So it seems from the evidence that it wasn't semen on the tablecloth. We know from the testimony of the complaining witness at trial that the sexual assaults themselves happened elsewhere. And so the state of the evidence in this case, all it does is exclude Mr. Jardine from those stains on the tablecloth. But that doesn't come close to excluding him as the perpetrator. What it does, it raises a reason, and I think this is what the criminal court found in the Rule 40 petition. It raises essentially a reasonable doubt, which undermines the court's confidence in the guilty verdict.
And of course, when the court was making that finding, he did not have the benefit of Chapter 661B, right?
That's correct, yes. But again, we believe that there are still motivations that the petitioner could have sought for additional relief, like dismissal, or even sought to assert a freestanding actual innocence claim in order to try and obtain dismissal of his charges.
Mr. Rayner, Mr. Jardine moved for summary judgment on the B3 grounds, and he, in essence, said, disputed your interpretation of whether he had sufficiently pled a claim or established his entitlement to relief, and then went further and said, I have evidence that shows my actual innocence. And the state, I have that your opposition really didn't engage on that issue at all, and didn't put in opposing, affidavits, didn't put in opposing, didn't really even argue the issue. So if we disagree with you on the B1 issue, why wouldn't we, or shouldn't we go ahead and enter summary judgment, or direct that there should have been summary judgment on liability and send the case back for damages?
Well, the position we've made is that the arguments made as to why summary judgment should have been granted as to 661B-3, the only arguments made were the arguments based on res judicata and collateral estoppel. And so the state opposed those arguments, and given that those were the only arguments actually made as a reason for the court to grant summary judgment on that issue, the state has opposed those, and we don't believe res judicata or collateral estoppel applies. And on that basis, we think we did in fact dispute the sole basis for summary judgment that petitioner argued for.
So all of this information we have related to factual information. I thought there was a declaration, perhaps I misunderstood, a declaration from Mr. Jardine in support of his motion for summary judgment, that he was innocent, excerpts of witness testimony. That all was just only relevant to collateral estoppel and res judicata,
Well,
and you chose not to engage with that.
Well, it wasn't argued. It wasn't argued, in the summary judgment briefing, I don't believe, as a basis for granting that. And then the state responded to the arguments that were made as the petitioner made in favor of granting summary judgment, and those reasons were opposed.
So your argument, although this evidence was presented to the court, they were not, Mr. Jardine was not seeking summary judgment on that ground, and he had solely limited his argument to res judicata. Is that
that's
correct?
right. Yes.
All right. Anything further for the court at this time? Oh, I'm
Yeah,
sorry.
no, I'm sorry. I actually had the same question, and maybe I misread the summary judgment that was filed by Mr. Jardine. But what, if any, evidence did you folks put in to counter any evidence of innocence? In other words, what evidence of guilt did you folks offer up in opposing the summary judgment?
Well, I mean,
If
there's evidence from the trial record already in the summary judgment record. And so, our argument would be based on the evidence that's already in there from the trial would be sufficient.
You have any specifics, though, as to what evidence countered the evidence of innocence?
Well, for example, the new DNA evidence the petitioner has presented, it didn't negate the eyewitness testimony that was the basis of the conviction at trial. And so, that would be one example of the basis for opposing that.
I'm not following that. Can you explain that? I'm sorry. When you say the DNA evidence?
The new evidence that petitioner presented, even if it creates a reasonable doubt as to...
What conclusively excluded. That was the findings, and I believe that stands unchallenged at this point.
Conclusively excluded as the donor of DNA
Correct.
on that one piece of evidence,
Correct.
but not as the perpetrator. And so, the state's position would be there is still sufficient evidence in the trial record to demonstrate that petitioner is not actually innocent.
Which is my question. What other specific evidence did you folks point to in opposing the summary judgment that showed guilt?
Well, so just to be clear, when we opposed summary judgment, the only argument we made was that collateral estoppel and res judicata didn't apply, because those were the arguments that petitioner made. So the state didn't point to, go through the evidence and say, this, and this points to the defendant's guilt. We responded to the arguments the petitioner made as to res judicata and collateral estoppel and explained why those didn't apply.
But Judge Kawano seemed to engage. He said, even assuming an actionable claim, the evidence presented by petitioner, taken in the light most favorable to the state, fails to show there is no genuine issue of material fact as to his actual innocence. So contrary to what you're suggesting, Judge Kawano seemed to think that it was appropriate to engage on that evidence. And he said, well, I'm looking at the petitioner's evidence, it's not enough to establish an absence of a question of fact.
Well, yeah, I know. I mean, I think we, as part of the summary judgment motions, we argued that, you know, in arguing that the findings in the Rule 40 petition were not equivalent to actual innocence, I think those essentially go to the same issues. So, you know, we discussed the evidence that the new DNA, we discussed what the new DNA evidence showed, and the argument is that in addition to the trial record, is not sufficient to establish by preponderance of the evidence that the petitioner is actually innocent. So I guess the state's position is that the evidence that's already in the record from the trial and what petitioner presented is sufficient to defeat the motion for summary judgment.
Well, anything further to wrap up for the court at this time, Mr. Rayner?
Thank you.
All right. Mr. Kelly.
Thank you. First, I want to address the issue as to what evidence was or wasn't in the record at the time of summary judgment. We moved for summary judgment in a very traditional sense. We presented facts to show our client was innocent and submitted exhibits. There were 25 exhibits, almost 200 pages of evidence that we presented showing our client was innocent of this crime. The state argues to this identification of our client as if it's a fact and evidence, and it wasn't there. That wasn't contained in their opposition, and that wasn't certainly an exhibit that we submitted. And a part of that, I have to say, is that in these cases, I've learned from my client, he's spoken across the country about exoneration. It's not uncommon that a person, when they understand of the newly discovered DNA evidence, that a complainant may change their mind. And we would invite that. And I'm not going to pull this poor woman into court, but if I would, for them to argue that she's still identifying our client as the assailant, as the person responsible for that, they need to actually submit admissible evidence that that's the case, because a lot has changed since she last testified, since she was presented with this suggestive photo ID lineup. The state argues still strongly that there's no factual equivalent of actual innocence in the vacatur order issued by Judge August. I'm going to read verbatim from Judge August's conclusion. This is part of the conclusions where he vacated the criminal conviction. He says, quote, "The primary issue in the original case," that's Mr. Jardine's criminal case, "and the instant issue is the identification of the perpetrator of the crime, and the new potentially exculpatory DNA evidence goes to the identity of the perpetrator of the crime." Now, again, he inserts the word exculpatory, even though it's not part of the McNulty standard. Exculpatory means, quote, "clearing or tending to clear from alleged fault or guilt." I'm quoting from Black's Law Dictionary. Innocence means freedom from legal guilt of a particular crime or offense. We submit that stronger words could not have been used by our criminal trial court judge regarding the significance of this newly discovered evidence in vacating this order, and that order is the equivalent of saying that, yes, this newly discovered evidence goes to innocence. It is the equivalent of it, and about as close as you can get. And in fact, DNA evidence is commonly cited to as the basis for even enacting these statutes. It's one of the few times that we'll have a conviction set aside on reasons other than technicalities, such as a confession that should have been suppressed and was failed to be suppressed, or other more clerical issues, I should say, or even perhaps constitutional issues of suppression of evidence. This case wasn't about excluding evidence. It was about bringing forth more evidence to justify a trial on this case. So we submit that under the circumstances, Mr. Jardine should be given his day in court, one. In other words, the statute needs to be interpreted in a way that's not absurd, that gives an individual who has been wrongfully convicted at least the opportunity to come to court and show actual innocence.
I just want to make sure I understand.
Yes.
It is your position that if there is a confession that is later set aside, there can never be a finding of actual innocence?
That is, given the precedents across the country, yes, the suppression of evidence may go towards an issue of legal innocence. In other words, was there evidence sufficient? But that does not Across the country, the courts have stated that doesn't go to actual innocence. Did he do it or did he not do it?
But you would not discount the possibility that, like, obviously there are false confessions, and confessions are set aside, and then sometimes there's people that come forward and admit to the crime. So you're not conceding that
Well-
this statute couldn't apply in such a situation. You would have additional evidence of somebody else that that admitted,
Oh, well,
confessed to the crime.
yeah, certainly under that circumstance, if it's based upon evidence of innocence, in other words, a confession that may have been bunk, may have been wrong, as well as it wasn't our client, it was someone else, then that goes to, we would submit that would go to actual innocence. But if this was simply an issue of, let's say, a traffic
Well,
stop.
we shouldn't be addressing any of these issues because it's not before us, correct?
Please, yes.
Yeah.
Thank you, Justice.
Mr. Kelly, Mr. Rayner, again, coming back to your motion for summary judgment and you reminded us that you've put in 200+ pages of evidence establishing, in your view, your client's innocence. Mr. Rayner's response is, well, all that the state understood was that you were arguing res judicata and collateral estoppel. So if we disagreed with your arguments on those points, I guess the suggestion would be that you had not identified his actual innocence, factual innocence, as something that was in play. Could you respond to that, please?
Well, our motion for summary judgment, docket 103 does have Mr. Jardine's declaration. He's attesting he is actually innocent in this case. The res judicata collateral estoppel arguments, they went to the fact that in the criminal case before Judge August, there were findings. They were stipulated to by the state of Hawaii regarding this DNA evidence. Those issues, we believe, should not be contested. But regardless, if you do not even consider those arguments, we had additional facts to say he didn't commit this crime. We argued this as a traditional motion for summary judgment. Our reply brief, I'm certain, says that once we meet our initial burden, it shifts, just as it does in every summary judgment motion. And it shifted to the state when we presented evidence saying he's innocent through declaration, through testimony, and even through the conclusions reached in the criminal case regarding this DNA evidence being exculpatory and that his DNA wasn't found at the scene, at least on the tablecloth. Well, quite frankly, it wasn't found anywhere. There is no DNA evidence. The original FBI analysis in no way connected our client to the scene, and then the subsequent analysis went further, saying, yes, there's male DNA here, exactly where the rape occurred. There's actually, at least where a sweaty man was sitting, and there was blood from both the victim and a male contributor, and it was not Mr. Jardine. But going back to your question, there isn't a scintilla of evidence that they submitted in their opposition to say he did it, that he is the perpetrator, or they even identified him as the perpetrator. They cite to a criminal record which was not brought in to our civil case, which is their burden, and they failed to meet that.
Very well. Anything else to wrap up for the court at this time?
No, thank you for your time.
All right. Very well. Thank you to both of our counsel. The court will take this matter under advisement.
Eku Iluna, please rise. Ua ho'oku ia mai nei ke aha ho'okolokolo ki'i ke hanahano o ka waka aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.